Nevaeh never thought she would have to fight her own parents for what her grandmother left her. She was 31 years old, living in Charlotte, North Carolina, working two jobs, sending money home when she could, being the kind of daughter and granddaughter that families quietly depend on and publicly overlook. She had spent every summer of her childhood at her grandmother Me's house on Sycamore Lane. Every holiday, every hard moment. She had been the one holding Me's hand in the hospital during the final weeks, sleeping in the chair beside her bed, the same way she always showed up, completely, without condition. Me had told her, directly, clearly, more than once. Nevaeh, that house belongs to you. So when the family attorney read the will 3 days after the funeral and Nevaeh's name was nowhere in it, the room went cold in a way that had nothing to do with the temperature. Her parents sat across from her with the composed expressions of people who had already known what the document would say. But then, 2 weeks later, Nevaeh's phone rang. A realtor named Sandra, calling from a number Nevaeh didn't recognize. Her voice was shaking. Her words came fast, and what Sandra said in the next 90 seconds changed absolutely everything. What Sandra found attached to that deed, and what Me had quietly done 14 months before she passed, you will not see coming. Subscribe right now and hit that bell. This story gets deeper with every part. My name is Nevaeh. I am 31 years old and I live in Charlotte, North Carolina. Before I tell you what happened, I need to tell you about me. My grandmother was the kind of woman who made every space she occupied feel like somewhere you were supposed to be. Her house on Sycamore Lane in Greensboro was not large or grand or particularly remarkable to anyone who drove past it, but to me, it was the most important place in the world. I spent every summer there from the time I was 6 years old. Every Thanksgiving, every Christmas, every moment when my own house felt too loud or too complicated or too much, I found my way to Sycamore Lane. Me always opened the door before I knocked, like she heard me coming from down the street and had been waiting. I loved her more than I have words for. And she knew it. And she showed me she knew it in ways that I only fully understood after she was gone. The house on Sycamore Lane was a 3-bedroom brick ranch built in 1962. Me had lived there for over 50 years, longer than my parents had been alive. She had raised her children there, buried a husband from there, weathered every hard season of her life inside those walls and emerged from each one still standing, still warm, still entirely herself. To the outside world it was property. Square footage, a number on a tax assessment. To me, it was the kitchen where Me taught me to make her biscuits on Saturday mornings. The back porch where we sat in the evenings watching the yard go dark. The small bedroom at the end of the hall that was always made up and always waiting, that she called Nevaeh's room even when I was not there. Me understood what that house meant to me. She told me so, more than once. In plain language that left no room for misinterpretation. That house was mine. She had decided it, she had said it. I had believed her completely. Me was diagnosed with congestive heart failure when I was 29 years old. The diagnosis itself was not a complete surprise. She had been slowing down for a couple of years, and Me was not the kind of woman who hid things from the people she loved. She told me directly, the way she told me everything, sitting at her kitchen table with coffee between us like it was any other conversation. What changed after the diagnosis was the level of support she needed. And what became clear very quickly, to anyone paying attention, was that I was the one providing it. I drove to Greensboro every weekend for 11 months. Managed her medications, her appointments, her insurance paperwork. Stayed through the hard nights when her breathing was labored and the fear in her eyes needed someone present more than it needed anything else. My parents visited occasionally. Briefly. With the energy of people fulfilling an obligation rather than showing up for a person they loved. Me noticed. She never said so directly, but she noticed. Me said it for the first time on a Sunday evening in March, about 8 months before she passed. We were sitting on the back porch the way we always did in the evenings. The yard was dark and the air had that early spring quality, cool, but with something warmer underneath it, and Me was wrapped in the blue cardigan she wore constantly that year. She reached over and put her hand on mine and said, "Nevaeh, I need you to know that this house is going to you. I have taken care of it. It is yours." I told her she didn't need to talk about that. She shook her head and said, "Yes, I do. I need you to hear it and I need you to know I mean it." She said it 2 more times in the months that followed, different conversations, different evenings, always the same clarity, always the same certainty. I heard her. I believed her. I had no reason not to. Me passed on a Tuesday morning in October. I was there. I had driven up Sunday when the hospice nurse called to tell me the timeline had shortened significantly. I had slept in the chair beside her bed for 2 nights, the same chair I had pulled close to her bedside more times than I could count over the past year. My parents arrived Monday evening. They stayed a few hours and went to a hotel. They said they would be back in the morning. They were not back in time. Me passed at 6:42 in the morning with my hand in hers, and the early October light just beginning to come through the curtains she had hung in that room 30 years ago. I sat with her for a long time after. Not ready to let the room change yet. Not ready for what I knew came next: the phone calls, the arrangements, the machinery of loss that begins moving the moment someone leaves. I just sat with her. Quietly, the way she had always sat with me. The will reading was scheduled for Thursday morning, 3 days after the funeral. I drove to Greensboro from Charlotte the evening before and stayed at a hotel 2 miles from Me's house. I could not bring myself to stay in the house alone yet. It felt too soon. Too quiet in the wrong way. I dressed carefully Thursday morning. Me had always cared about how you presented yourself in professional settings. She called it showing up with intention, and I wanted to honor that even in this. I arrived at the attorney's office at 9:50 for a 10 o'clock appointment. My parents were already in the waiting room. My mother hugged me. My father put his hand briefly on my shoulder. They were composed in a way that I registered without examining, the composed quality of people who have already processed something and are now simply waiting for the formality of it to conclude. I sat down across from them and waited for the attorney to begin. The attorney was a man named Gerald Totham, older, methodical, the kind of professional who moves through legal documents with complete neutrality and communicates nothing through his expression. He read the will clearly and without interruption. My parents received the contents of Me's savings and checking accounts, combined value just over $60,000. They received her personal property, furniture, jewelry, household items. They received the vehicle. Then he closed the document. I waited. He began discussing next steps, estate administration timelines, account transfer processes, paperwork that would need to be filed. I stopped him, politely but directly. I asked about the house on Sycamore Lane. Gerald Totham looked at me over his glasses and said the house had been included in the estate assets transferred to my parents as primary beneficiaries. I looked at my parents. They did not look surprised. They did not look uncomfortable. They looked like people sitting in the exact outcome they had prepared for. And that, more than anything Gerald Totham had just read, told me everything. I drove back to Charlotte from that attorney's office alone, 2 hours on I-85 South with the windows up and the radio off and my hands steady on the wheel, because I needed at least one thing in my body to behave normally while everything else was doing the opposite. I kept replaying the moment. Gerald Totham closed that document. The way my parents had sat there, composed, unhurried, already oriented toward next steps before I had even processed that my name was nowhere in what he had just read, that composure was the thing that stayed with me. Grief makes people unpredictable and raw and present in ways they cannot fully manage. My parents had not looked like people sitting inside a loss. They had looked like people sitting inside an outcome. There is a difference. And I had felt that difference in that room like a temperature change. Something had been done, deliberately. And they had known it was coming long before Thursday morning. I called my cousin Deshawn that evening, the one person in the family who had spent real time with me over the years and whose read on family dynamics I trusted completely. He answered on the second ring and I told him everything. They will read. My name is missing. The house is going to my parents, their composure in that room. Deshawn listened without interrupting, which was unusual for him, and told me he was taking it seriously. When I finished, he was quiet for a moment. Then he said something that shifted the entire frame of how I was looking at the situation. He said, "Nevaeh, do you remember last Christmas when Me pulled me aside and told me she had handled something important, that she had made sure certain things were taken care of properly?" I said I didn't know about that conversation. He said she was specific about it. She said, "Deshawn, I have made sure Nevaeh is protected. I want you to know that." I sat very still on my couch in Charlotte and felt something move in my chest. Me had said that. 10 months before she passed, she had told Deshawn she had made sure I was protected. I did not sleep well that night. I lay in bed running through every conversation I could remember with Me over the past 2 years, not just the ones where she had told me directly that the house was mine, but all of them. The quieter ones. The ones where she had said things I had registered and filed away without fully examining. By morning, I had a notepad beside me with dates, fragments of conversations, names of people who had been present during certain discussions. I was not a lawyer. I had no legal training. But I was organized. I had always been organized. And I understood instinctively that if something had been done to that, well, it had not been done invisibly. Documents leave records. Dates leave records. People who accompany elderly women to attorney offices leave records. I got up before 6, made coffee, and started writing down everything I knew in chronological order. It was the most important list I had ever made. I called Gerald Totham's office 2 days after the will reading. I was polite and professional. I had thought carefully about how to approach this, and had decided that direct and calm was more likely to get me information than emotional or accusatory. I identified myself as a beneficiary named in a previous version of the estate documents and asked whether I could obtain information about when the current will had been executed and whether there had been prior versions on file. The receptionist was pleasant, put me on hold, came back 3 minutes later and told me that estate documents were confidential to the named beneficiaries and that I would need to speak with the executor, my parents, if I had questions about the estate administration. I thanked her and ended the call. That response told me more than an answer would have, because a straightforward question about document dating should have generated a straightforward response. The redirect to my parents, who were the people I was questioning, was not accidental. Something in that office was being protected, and now I knew where to look harder. I contacted the Guilford County Register of Deeds office directly, not the attorney, not my parents, but the county office that maintained public property and estate records. I requested a copy of Me's will history, specifically any amendments or codicils filed within the last 2 years of her life. The document arrived by email 3 days later. And what I found inside it confirmed what Deshawn's words had already begun telling me. Me's will had been amended 14 months before her death. A formal codicil, filed through Gerald Totham's office, that had restructured the estate distribution and removed the specific bequest that had previously designated the Sycamore Lane property to me, 14 months before she passed. I pulled Me's medical records from that same period, records I had access to because I had been her healthcare proxy during her final year. Her cognitive assessment from that month showed the beginning of documented decline. Not severe, not incapacitating, but present. Measurable. Noted by her physician as a reason to ensure any significant legal decisions were being made with appropriate support and oversight. The timing was not coincidental. I was certain of it. The codicil document contained a witness signature block, 2 witnesses required by North Carolina law to validate the amendment. I read the first witness name. A notary from Totham's office. Expected. Standard. I read the second witness name and set the paper down on my kitchen table. My father. My father had witnessed the amendment to Me's will. The amendment that removed my name and redirected the house to my parents as part of the general estate. He had signed his name as a witness to a document that directly benefited him, a significant legal conflict of interest that raised immediate questions about whether Me had been given independent counsel or whether the people guiding her through that appointment had interests that were not aligned with hers. I sat at my kitchen table in Charlotte for a long time. Me had been declining cognitively. She had been taken to an attorney's office by or with my father. She had signed a document that contradicted what she had told me, and Deshawn, and almost certainly others, directly and clearly for months, and my father had signed his name as a witness. I slept on it, one night. That was all I allowed myself, because I understood that what I was considering was not small. Taking legal action against my own parents. Challenging a will in court. Putting my name and my family's name into a process that would be documented and examined and would not stay quiet. I thought about Me in that attorney's office, whether she had fully understood what she was signing, whether she had asked for me, whether she had wanted to call me and had been told it wasn't necessary, whether the woman who had sat on the back porch and told me clearly, "This house is yours, I have taken care of it," had known in that room that what she was doing was the opposite of what she had promised. I did not believe she had known. I did not believe that for a single second, and by morning I had my answer. I was not letting this go, not for family peace, not for the cost of the fight, not for any reason that I would have to live with later and explain to myself in the quiet. Me had told me that house was mine, and I was going to find out what she had actually done to make sure of it. I was at work when my phone rang, Wednesday afternoon, 12 days after the will reading. I was in the break room at my second job, a retail position I worked 3 evenings a week to cover the gap between my primary income and my Charlotte rent, and I almost let it go to voicemail, because unknown numbers during shifts usually meant nothing worth interrupting a break for. Something made me answer. The woman on the other end identified herself immediately. Sandra Pierce, licensed realtor with Carolina's premier properties in Greensboro. Her voice was professional, but underneath the professionalism was something else. A tension that people carry when they know they are about to say something that is going to matter significantly to the person they are saying it to. She asked me to confirm my name before she said anything further. I confirmed it, and then stood up from the break room table without realizing I had done it. Sandra spoke carefully, the way people speak when they have rehearsed an opening, but are not entirely sure how the conversation is going to unfold once it begins moving. She told me she needed to ask a direct question before she explained why she was calling. She asked me whether I had any connection to a property on Sycamore Lane in Greensboro, specifically whether I had any legal interest in or claim to that address. I told her my grandmother had lived there for 50 years, that she had passed 3 weeks ago, that I had been present for her final year of life, and that me had told me directly, more than once, that the house was mine. Sandra was quiet for just a moment after I said that. Then she said, "That is what I was afraid of, and that is exactly why I needed to call you." Her voice was steady now, but I could hear something underneath it that I recognized, the specific tension of someone who has discovered something they cannot know and has decided to do the right thing about it. Sandra explained the situation clearly and without editorializing, which I appreciated more than she knew. She had been contacted by my parents approximately 10 days after Me's funeral. They had introduced themselves as the legal heirs of the estate and had engaged her services to list the Sycamore Lane property for sale. They wanted it listed quickly, her word was urgent, and had provided the necessary estate documentation to proceed. Sandra had begun the standard listing preparation process. Photography scheduled, comparative market analysis completed, disclosure documents drafted, all routine, all standards. She pulled the full property record from the Guilford County Register of Deeds to complete her title research, and found something attached to the deed that her clients had not mentioned, had not disclosed, had given her no indication existed at all. She paused at that point in her explanation, and I gripped my phone tighter and waited. Sandra told me she had been a licensed realtor in North Carolina for 16 years. She said she had encountered complicated property situations before, disputed titles, estate irregularities, clerical errors that created problems nobody anticipated. She said this was different, that what she found attached to the deed was not a complication or an error. It was a document, filed properly, recorded officially, stamped and dated by the Guilford County Register of Deeds 14 months before Me's passing. She described it to me carefully, its formal name, its legal structure, what it meant under North Carolina property law, and as she spoke I felt something happening in my chest, not quite understanding yet, not the full picture, but the beginning of something shifting. The first movement of something enormous that had been completely still. I asked her to say the document's name again. She did. And I sat back down in that break room chair, because my legs had made a quiet decision without consulting me. The document Sandra had found was a transfer on death deed. In North Carolina, a transfer on death deed, sometimes called a beneficiary deed, allows a property owner to designate who receives their real property upon their death without the property passing through probate or being subject to the terms of a will. It transfers automatically, directly, at the moment of death. Me had filed one, 14 months before she passed, during a period when, as I would later document carefully with her medical records and the testimony of her hospice nurse, she had been in a period of relative cognitive clarity before her condition progressed further. She had gone to the Register of Deeds office herself, had the document properly witnessed and notarized, had it officially recorded with the county, and on that document, in the designated beneficiary line, was my name. Nevaeh, spelled exactly the way me had always spelled it in birthday cards and letters my entire life. I pressed my hand flat against the break room table and just breathed. Sandra explained the legal significance clearly, and I could tell from the way she spoke that she had already done her research before making this call. Under North Carolina law, a properly executed and recorded transfer on death deed supersedes the terms of a will with respect to that specific property. The will could distribute everything else in Me's estate, the accounts, the personal property, the vehicle, and my parents were entitled to all of that. The will was valid for everything it covered, but it could not override the transfer on death deed, because the house on Sycamore Lane had already been legally designated, already recorded, already, from the moment Me filed that document, set apart from everything else she owned. The will amendment that removed my name had been filed 8 months after the transfer on death deed, which meant whoever had facilitated that amendment, and whoever had encouraged it, had either not known about the deed or had known and hoped nobody would look closely enough to find it. Sandra's title search had looked closely enough. Sandra told me she had paused the listing the moment she found the deed. She had not called my parents to explain why. She had not contacted Gerald Totham's office. She had not filed anything or made any formal moves. She had simply stopped the process, quietly, within her own authority as the listing agent, and picked up the phone to call me. She said, "I have been doing this for 16 years, and I have a very clear sense of when something is not right. What I found in that property record is not right. And I was not going to list a house for people who I believed were not entitled to sell it without making sure the person who might actually be entitled to it knew what existed." I asked her why she was willing to do that. Why would she risk the professional relationship with my parents, the paying clients, to make a phone call to a stranger? She was quiet for just a moment. Then she said, because your grandmother took the time to file that document. She did it deliberately. She did it clearly. And somebody needed to make sure it meant something. I had to set my phone down for a second after that. Just for a second. I called Rebecca Cole the same afternoon Sandra called me. I had written her name down 3 days earlier. Deshaun had mentioned her after I told him what I was uncovering. He had a colleague whose family had used her for an estate dispute and had described her as someone who did not take cases she did not intend to win. She answered her own phone, which I had not expected. I introduced myself and told her I had a situation involving a transfer on death deed, a contested will amendment, and parents who had engaged a realtor to sell a property they did not legally own. She asked me 2 questions. Clean and direct. How recently had the property owner passed, and did I have documentation of the transfer on death deed in hand? I said 3 weeks and yes. She said, can you come in tomorrow morning? I rearranged my entire work schedule without hesitating and said yes. I brought everything to Rebecca's office the following morning. The transfer on death deed Sandra had found. Me's medical records from the 14-month period surrounding the will amendment. The codicil document showing my father's signature as witness. Deshaun's written account of Me's conversation with him at Christmas. The chronological notes I had been building since the night after the will reading. Rebecca went through each document without speaking. She reads carefully, the kind of reading that is also analyzing, cross-referencing, building something in real time. When she finished, she set everything down and looked at me directly. She said the transfer on death deed was clearly executed and properly recorded. She said the cognitive decline documentation, combined with my father's witness signature on the amendment, created serious questions about the validity of that codicil. She said the conflict of interest alone was significant enough to warrant legal review. Then she said, Nevaeh, your grandmother protected you. Our job now is to make sure that protection holds. Rebecca filed an emergency motion to freeze the Sycamore Lane property the following morning. The motion requested that the court issue an immediate order preventing any sale, transfer, listing, or material alteration of the property pending full legal review of the competing claims, the transfer on death deed versus the will amendment, and the circumstances under which the amendment had been executed. She filed it in Guilford County Superior Court before 10 a.m. By 2 o'clock that afternoon, the court had issued a temporary restraining order on the property. Sandra received official notification that afternoon and called me immediately, her voice carrying the specific relief of someone who had made a difficult call and was now watching it validated in real time. She told me the listing was formally suspended, that she had already contacted my parents' representative to inform them the property could not proceed to market. She said my parents' representative had not taken the news calmly. I thanked Sandra and sat down and felt the first solid ground beneath me since the morning me passed. My parents were notified of the emergency motion and the restraining order by Rebecca's office the following day. I had prepared myself for anger, for phone calls, for the kind of family pressure that comes when legal action makes a private situation suddenly formal and documented and impossible to manage through conversation alone. What I had not fully prepared for was how quickly their response revealed the thing I had suspected but not yet proven. My father's attorney contacted Rebecca within 4 hours. The response was detailed, specific. It addressed the transfer on death deed directly, not with surprise, not with confusion, but with a prepared counter-argument that had clearly been constructed in advance. They knew about the deed. They had known about it before Sandra found it, before I engaged Rebecca. Possibly before me even passed. Rebecca called me after speaking with their attorney and said, carefully, professionally, with the controlled tone of someone delivering significant information, Nevaeh, their response tells me they were aware of the transfer on death deed and proceeded with the sale listing anyway. That changes the nature of what we're dealing with considerably. Rebecca's investigative work over the following 2 weeks uncovered something that added an entirely new dimension to everything. Gerald Totham, the attorney who had facilitated Me's will amendment, had a prior professional relationship with my father. Not recent and not widely known, but documented. 7 years earlier, Totham had handled a business matter for my father's company. A straightforward engagement, nothing improper on its own, but a relationship that created a professional conflict of interest when Totham later facilitated changes to a will that directly benefited that same former client. North Carolina bar rules required disclosure of such conflicts before proceeding. Me should have been informed. She should have been given the opportunity to seek independent counsel. She had not been. Rebecca documented everything carefully. The prior engagement, the failure to disclose, the timing relative to Me's cognitive decline, the presence of my father, a direct beneficiary, as a witness to the amendment. Each piece individually was significant. Together, they formed something that went beyond a civil property dispute into territory that had regulatory and potentially criminal implications. Rebecca submitted a formal referral to the North Carolina State Bar regarding Gerald Totham's conduct. Within the same week, she uncovered the conflict of interest documentation. Separately, and this was the part that made me sit very still when she told me, she had contacted the Guilford County District Attorney's Office regarding the potential elder financial abuse implications of the case. Elder financial abuse in North Carolina carried serious consequences. And the combination of elements present in Me's situation, documented cognitive decline, a beneficiary present as a witness during a document signing that benefited him directly, an attorney with an undisclosed conflict of interest, and a subsequent attempt to sell property the sellers did not legally own, created a picture that the DA's office had agreed warranted review. I had not asked Rebecca to go that far. She had made the referrals because the evidence pointed there, and she believed in following evidence wherever it led. She told me about the referrals on a Thursday afternoon phone call. I was sitting in my car in a parking garage in Charlotte after a 12-hour shift. I sat there for a long time after we hung up, thinking about me, about what had been done to her, about the fact that somewhere in the process of trying to take what was mine, they had exposed what they had done to her. And that mattered more to me than any property ever could. The validation hearing was 3 weeks away when I sat across from Rebecca in her office for what felt like the first real pause in the momentum of everything that had been moving since Sandra's phone call. Rebecca walked me through the hearing preparation. What to expect, how the court would evaluate the competing documents, the strength of our position. She was thorough and calm, and I trusted her completely by this point. When she finished, I asked her one question. I asked, not about the house, not about the legal outcome, not about my parents or the investigation, or any of the practical machinery of what we had built together over the past weeks. I asked her whether she thought me had known what she was doing when she filed that transfer on death deed, whether she had understood clearly what it was and what it would do. Rebecca looked at me for a moment. Then she said, everything about how that document was prepared and filed suggests a woman who knew exactly what she was doing and exactly why. She went to that office alone. She brought proper identification. She answered all required questions clearly. The notary's record shows no concerns noted at the time of execution. She paused. Your grandmother filed that document to protect you. She did it deliberately. And she did it while she still could. I nodded, looked at my hands on the table. That was the only answer that had ever really mattered. The validation hearing was scheduled for a Friday morning in March. I drove to Greensboro the evening before and stayed at the same hotel I had stayed at the night before the will reading. Same room as it happened, same window, same quiet street outside. I sat at the small desk by the window for a long time before I could sleep. I thought about the distance between that first Thursday morning and this one. How much had moved? How much had been uncovered? How much me had quietly set in motion before any of us were ready to understand it. The hearing itself was clean and uncomplicated. Rebecca had prepared everything with the thoroughness of someone who left no surface unexamined. The transfer on death deed was authenticated. The timeline is documented precisely. The cognitive clarity evidence from the period of filing, presented and accepted without challenge. The judge reviewed everything carefully. Asked Rebecca 2 clarifying questions. Then looked down at the documents one final time, and signed the validation order. Me's house on Sycamore Lane became mine. Legally, officially, without condition. The elder financial abuse investigation had been moving quietly alongside the property case for 2 months. Rebecca had referred the matter to the Guilford County District Attorney's Office and the North Carolina State Bar simultaneously. The bar investigation focused on Gerald Totham, specifically his undisclosed prior relationship with my father and his failure to ensure me had independent counsel before signing documents that directly benefited a former client of his. The DA's office was examining the circumstances of the will amendment itself, whether me had been in a condition to give genuine informed consent, whether the people present during that appointment had accurately represented her wishes or their own. I was not driving those investigations. I had provided documentation when asked and answered questions when called. But the process had its own momentum now, the way legal processes do when the evidence is clear and the paper trail leads somewhere specific and unavoidable. My parents were no longer composed. That much had reached me through Deshawn, carefully, without detail, but enough for me to understand that the outcome they had prepared for so confidently was not the one arriving at their door. I called Sandra the morning after the validation hearing. She had submitted her formal statement to Rebecca's office weeks earlier and had agreed without hesitation to serve as a witness if needed. She had been steady and professional throughout, never dramatic, never seeking any part of the attention, and I had thought about her often during the weeks of legal process that followed her phone call, about what it had cost her to make that call, the clients she had walked away from. The professional discomfort of doing the right thing when stepping around it would have been so much easier, she answered warmly. I thanked her properly, the way the moment deserved, not quickly or briefly, but with the full weight of what her decision had meant. She said, Nevaeh, your grandmother filed that document for a reason. She made it clear and she made it legal and she made it findable. I just found it. You did everything else. I told her that finding it had been everything. Without that phone call, none of the rest existed, she said quietly. Then I'm glad I trusted my instincts that afternoon. I drove to the house the Saturday after the hearing. I had been inside a few times during the legal process, briefly, practically, for things that needed handling. But this was different. This was the first time I drove down Sycamore Lane as the owner. The legal, documented, court-validated owner of the house my grandmother had promised me on a cool back porch evening 2 years ago. I parked in the driveway and sat in my car for a moment. The brick was the same. The yard was the same. The small flower bed along the front walk that me had tended every spring was overgrown. It had been a hard fall and a harder winter and nobody had been caring for it, but the bones were still there. Still holding the shape she had given it over 50 years of patient attention. I got out of the car. I walked to the front door. I put my key in the lock. The door opened the way it always had, with that specific slight resistance in the handle that I had felt 10,000 times since childhood and that my hand still remembered without being told. I walked into Me's house. My house. And stood in the entryway in the quiet. I found it in the kitchen. Me had a specific drawer, left side cabinet just beside the sink, that she called her important drawer. Not files or formal documents, just the things she considered worth keeping close. Takeout menus from her favorite places. A small notebook with phone numbers written in her careful hand. Birthday cards she had particularly loved receiving over the years. I opened it without expecting anything specific, just moving through the house slowly, taking stock, being present with each room. At the back of the drawer beneath a takeout menu from a Chinese restaurant she had loved for 30 years was an envelope. My name on the front, her handwriting. I stood at her kitchen counter and opened it with the afternoon light coming through the window above the sink, the window she had stood at for 50 years looking out at the yard she loved. Inside was a single note card. 4 sentences, written in the deliberate, careful hand she reserved for things that mattered most. I read it twice. And I folded it against my chest and stood in her kitchen for a very long time without moving. I told Rebecca my decision the following week, and she was quiet for a moment before she responded. I was not selling the house. I had considered it practically and honestly. The property represented real value, and my financial situation was one that could genuinely benefit from that value being liquidated. I had run the numbers. I thought about it seriously without sentimentality for several days. Then I walked through those rooms again. I stood at the kitchen window, sat on the back porch in the early spring evening with the yard just beginning to show the first small signs of the season changing. I felt the specific quality of quiet that house carried, the kind that comes from decades of a good life lived carefully inside 4 walls. I was not selling it. I was going to restore it. The garden first, the flower bed along the front walk that needed to come back to what me had made of it. Then the interior carefully, without erasing what she had built. And when it was ready, I was going to live in it. Rebecca said, "That's not what I expected." I told her I knew. She said, "It's the right call." And her voice carried something that told me she meant it entirely and not just professionally. On a quiet Saturday in April, I sat on Me's back porch as the sun went down over Sycamore Lane. The garden was already better. 2 weekends of clearing and replanting, and the flower bed along the front walk was beginning to show the first small evidence of something coming back to life. The house was clean. The important drawer was still in its place. The note card was in my wallet, folded carefully, carried with me the way you carry something you need to feel the weight of on ordinary days. I had a cup of tea. Me's blue cardigan, the one she had worn through her last winter, the one I had found folded in her closet and could not bring myself to move far, was draped over the chair beside me. I sat in the evening quiet and watched the yard go slowly dark, the way I had watched it go dark beside her 100 times over a lifetime of evenings on this porch. She had known. She had planned. She had walked into that county office 14 months before she passed and made sure that what was mine could not be taken quietly in a room I wasn't invited to. She had created a paper trail deliberately, had made it real and recorded and findable, and had trusted that someone with enough integrity would find it. Sandra had found it. In Me's house, her porch, her garden, her important drawer, her 50 years of life lived beautifully inside these brick walls, had come all the way home. To exactly where she always meant it to be, to me.